Saves the day. All right. So those of you who joined us, we just went over housekeeping items. So in addition to Medicaid, Medicare, private insurance, which is our health insurance, another form of benefit is food assistance, used to be called food stamps, and HUD is subsidized housing, and then another type of Medicaid that provides a waiver. All right. All right. The most important benefits that we typically see are the medical coverage, which is Medicaid and Medicare, both government benefits administered through both federal. In Medicare's case, it's federal administration, and in Medicaid, it is a state administered benefit. And then SSI and SSDI, which are administered through the Social Security Administration. All right, supplemental security income is SSI, which is a cash benefit, and Medicaid is the medical benefit. Both of these programs have the exact same requirements. And those are that in order to qualify for both of these, the individual has to be meet the Social Security's definition of being disabled, and they have to have countable resources less than $2,000, and their income has to be low. So if they qualify, if they meet those two prongs of being considered disabled and having less than $2,000 in countable resources, then they can receive SSI. The maximum benefit amount this year in 2023 is $914. That amount typically gets adjusted every January. If your child is a minor, then not only will Social Security look at the child's countable resources and income, but they will also look at the parents. So what they call that deeming, that the parents' income and resources deem down to that child until they turn age 18. So many times we'll say to parents, if your child may not qualify for Medicaid, for SSI while they're minor, but minute they turn 18, even if nothing else changes in their life in terms of they're still living at home, they will now be able to get on SSI, because now Social Security is only looking at that child's income and resources. When I said in the prior slide that they're talking about that your countable resources have to be below $2,000, not all resources are countable. So here is a list of resources that we might have that are excluded. So they're not going to go against that $2,000 limit. So that includes household goods, your residence, your house, one vehicle, an irrevocable funeral contract, your life insurance that has a total face value of less than $2,000, and exempt trusts, which are the special needs trusts, which we're going to get into, as well as the stable accounts. So what is the value of the benefit if we go through and make sure that our child has less than $2,000? why do we want to do that? Or how much should we be looking to qualify our child for these government benefits? So if they qualify for SSI, as I said earlier, they will get up to $914 a month for their food and shelter needs. And then that amount will get adjusted every year. They may also qualify for SSDI benefits. So SSI, again, stands for Supplemental Security Income. SSDI stands for Social Security Disability Insurance. Sometimes people confuse the two and will say, which type of benefit does your child have? And they'll say SSDI when it's really SSI. It's important for us to know the difference. So SSDI is based on the finding that the child is disabled, that they meet Social Security's definition of being disabled, and that there is a work history that somebody paid into, and like that they take out of our paychecks, and then when they become disabled, then they qualify for Social Security disability. So it's disability insurance. Now, a child may not have a work history to be able to draw down SSDI. However, under the Social Security rules, if that child is considered to be disabled prior to age 22, then they may qualify on one of their parents' work histories when that parent becomes disabled, retires, or passes away. So the amount of that award would be if the parent retires or becomes disabled, that child would be entitled to 50% of that parent's benefit. It wouldn't reduce the parent's benefit. It's just used as a calculation for that child's benefit. When that parent dies, the SSDI benefit amount will be 75% of that parent's benefit. And if your question is, well, which parent? Social Security will look at whichever parent has the higher benefit amount, and they will give that to the child. The Medicaid is another government benefit that, as I said, is providing medical coverage. And what that includes is your traditional medical hospital care. It includes cost of prescriptions, basic dental vision. It's very basic. It may provide for, there's different types of Medicaid in Ohio. So it could be community or residential Medicaid, where we're living at home, or it can be institutional Medicaid. And typically we see that with older individuals who are going into a facility, and Medicaid will cover the cost of their care there. If your child is considered to be eligible for county DD board services, then they may also qualify for a Medicaid waiver, which is the traditional Medicaid that you see up here on the slide, but it also pays for additional services depending on whether the waiver is a self waiver, a level 1 waiver, or an individual options waiver. Those are just three different types of waivers that DD boards have available. And what they cover is like I said, the traditional health insurance, plus also services that person would need to help them live in the community as independently as possible. So for example, if they live in a group home or in an apartment with a roommate or by themselves, and they need assistance with the activities of daily living or housekeeping or transportation, that's what a Medicaid waiver will cover. So for some people, that's a very valuable benefit, and they want to make sure that a child qualifies for it. All right, so moving on to guardianship versus powers of attorney. So when a child is a minor, that child, the parent is considered to be the natural guardian of that child, which means that you are able to make all legal decisions for that child related to their education, finances, medical consent. You're able to sort of stand in their shoes and give consent or not, or make those decisions. But the moment your child turns 18, even if they have a profound disability, they are presumed to be competent, and the parent loses that ability to make decisions or be in that role in that child's life, unless they either are able to get a power of attorney, which we'll talk about in a little bit, or they're going to need to seek guardianship, and then will get, if they become that child's legal guardian, then they will be able to continue acting in that role and making decisions. In order to obtain a guardianship, first of all, guardianship is awarded by the probate court in the county that the child resides in. The probate court has to find, when we apply for guardianship, that the ward, the individual, the child, is legally incompetent. In other words, they're not able to, because of their condition, they're not able to take proper care of themselves or their property. The guardianship is necessary. In other words, there needs to be some decision making, and therefore we need a guardian, and that there is no less intrusive method. So in other words, there's no ability to have powers of attorney in place, and therefore we need to have a guardian. So guardian is the person that is appointed by the court to act on the ward's behalf, and they have to make their decisions based on what is the best interest of the ward. The ward is the individual, so in our case, it may be the child who is in need of a guardian. And then we've already talked about that incompetence is defined that because of the impairment that the individual has, they are considered to be legally incompetent. And we've already said this. All right. What are the reasons for guardianship? Well, if we need to have somebody managing money or property, say the child has a bank account and they're not able to manage it, we may need to have a guardian. As an aside, if the only money that child is getting is SSI benefits or SSDI benefits, we may not need to have a guardian for that, because Social Security Administration has their own way of protecting that child's funds, and by assigning what they call a representative payee. It's almost like guardianship, but it's what they do is they will, at the time that they award the benefit, they will tell whoever they designate as the representative payee, they'll tell them to go open up a new bank account with the rep payee's name attached to it, and then that's where the funds will be placed. And then and that individual can't take the money out without the representative payee. So representative payee is actually controlling those funds. And if those are the only funds that child has, then the preferred method is to just be a representative payee and not go and seek guardianship, because you will see as we talk about this, the layer of oversight for a guardian who's managing funds is way more. There's way more rules to that than just dealing with Social Security. If we need to make medical decisions, and there need to be medical decisions made, that might be a reason to have a guardianship. Placement decisions, where that child's going to live or ward, I should say. Do they need a different setting, and they're not able to give consent, and that's what the guardian would do. Programming, what services they're involved in, what are they getting, are they working, what type of work, that all requires a guardian's consent. as well as education. If they're still in the school system and that parent wants to be involved in the IEP process, then they may need to seek guardianship. There are several types of guardians, and what we're talking about is Ohio requirements. So every state has guardianships, but they have different names for them, and they're slightly different. But in Ohio, we have the natural guardian is like I said, the parent of a child under age 18. They are going to be the natural guardian without any court involvement at all. Guardian of person is an individual who is designated the obligation to make decisions, all decisions that are not financial with respect to that ward. So that's the like placement, medical care, programming. Those are the kinds of things that the guardian of the person would decide. Guardian of the estate is charged with managing that ward's funds. Sometimes we have one individual that's appointed as both guardian of person and estate. Sometimes the court will divide that up, and that's depending on who the people are. The court will not appoint a guardian of the estate unless that ward has more than $25,000. So that's another reason that sometimes you might have just a guardian of the person, because we don't have the $25,000 minimum met. A limited guardian is someone that is appointed with limited power. So it could be for the purposes of setting up a trust, or for purposes of just dealing with medication. And then, so it's not the broad making all medical decisions or all financial decisions. It can be limited in scope and purpose. An interim guardian is if for some reason the guardian who's been appointed can't act, the court might appoint an interim guardian. Again, that would be time limited. And then sometimes we may need an emergency guardian because there's some sort of a risk to the individual. It has to be an imminent risk. So sometimes the family might say, well, we need to get a guardianship tomorrow, but what we think is an emergency may not be what the court thinks is an emergency. I mean, it really truly has to be a health or safety risk before they will appoint an emergency guardian. If an emergency guardian is appointed, that appointment is limited to a maximum of 30 days. So you still have to go through the process to get appointed as a regular guardian. All right, the requirements for a guardian are that they be over 18. The court has discretion to appoint anybody they want who meets this criteria. So it's an individual who's over 18. They're not incompetent themselves. If it's an application for guardian of person only, that person does not have to be an Ohio resident. They can be in another state. If it's a guardian of the estate, if we're applying for the authority to manage the ward's money, then the rules require that applicant must be a resident of Ohio. The only exception to that is if a parent, for example, names somebody that they want to be appointed as guardian of the estate in their will or in their power of attorney, or we tend to do a separate document that we call the nomination of guardian, where the parent can say, if my child needs to have a guardian of the estate, then I want this person to be appointed. And usually the court will follow that. If we do have a guardian of the estate, then the court will require that they be bonded by an insurance company. And a bond is like an insurance that is issued by a bonding company that guarantees that if that guardian takes off with the money, then the bonding company will make the guardianship whole, and then they'll go after the person who wrongfully took the money. The guardian has to be considered suitable. In other words, that the court believes that they will be able to make decisions that are in that ward's best interest. In general, an agency can't be appointed a guardian, although in the DD system, there is an agency that's created called Adult Advocacy and Protective Services, APSI for short, and their sole role is to be appointed guardian and serve as guardian in situations where there's an individual who needs a guardian and there's nobody suitable, or maybe they have a guardian, but the guardian is not acting in their best interest, or they're exploiting them, or neglecting them. And so the court will then ask APSI to step in and act as guardian. The person applying for guardian must not have been charged or convicted of crime of theft, violence, alcohol, or substance abuse. And that is a question that's on the guardian application. As we said, a parent may appoint a guardian of minor in their, well, a guardian of minor is different than guardianship of an adult. But if the parent passes away before that child reaches age of majority, they can appoint a guard. They can name somebody in their will that they would want to be appointed as guardian. If it's an adult child, then we can have that nomination included either in a power of attorney or separate document that is witnessed or notarized. We don't want to just do it in the will, because that's not going to be sufficient. All right, so we've said that an out-of-state guardian of the estate will only be appointed if it's in the writing that the parent left. This is kind of repeating it. If that child is over 14, then they can select and tell the judge who they want to be their guardian. All right, how do we initiate the application for a guardianship? So it starts with filling out the forms. So each court has their own forms. They're very similar, but there might be slight deviation. So, if you're living in Cuyahoga County, you're going to want Cuyahoga County's forms versus Lorraine County's forms. But those forms include a statement of expert evaluation. So what that is it's a form that has to be filled out by that child's doctor that asks for the medical information about the disability, as well as the doctor's opinion about whether they believe that a guardianship is necessary or recommended. So that gets filled out. Also, there's a notice that has to be provided to the individual as well as next of kin. So next of kin is the parents. If it's a child that's applying for their sibling, then the next of kin includes other children. Yes. And again, it depends on who's living. If the child, the other family members have a right to file a competing application. So if one sibling decides to file an application and then there's another sibling that thinks, no, I want to be guardian, you can have multiple applications, and that all gets sorted out at the guardianship hearing. Once the application gets filed, the case gets assigned to the court investigator, who will go out and meet your child. And they kind of have a dual role in doing that. One is to give them service, because that's what the rules require. In other words, they tell them, your mom or your dad has applied to be your guardian. Then they tell them that they also have rights. So rights include to ask to be represented by their own attorney, the right to be at the hearing, the right to say, I don't need a guardian, that kind of thing. And then, then they also tell them about the hearing. The other role of that investigator is to kind of lay their eyes and ears on that individual and be able to gauge or observe whether this seems like an appropriate situation that this child needs to have a guardian. Because most of the time when we have the hearing, that child is not at the hearing. They don't have to be. And so the judge may never lay eyes on them. So they're looking to the investigator. The investigator will, once they complete their visit, they will prepare a report for the judge with their opinion about what they observed and whether they think a guardianship is appropriate. All of that has to be done at least 7 days prior to the hearing. So when we file the application and it gets assigned to the investigator, at the same time, the court will schedule a hearing date. And that date will be typically, if it's Cuyahoga or Lorraine County, it'll be a month to 6 weeks out in order to give that investigator time to go and investigate. All right, we talked about this a little bit. The rights of that potential ward, that child, is they can ask to have an attorney appointed. If they don't agree with the expert evaluation, the statement of expert evaluation by the doctor, they can ask to have a separate one. Let me see here. I'm sorry. I just need to, I think there's some people that are trying to get in. Let me, bear with me here. Maybe we need to. Let me see. Bear with me. I want to make sure that people are not excluded if they're trying to get in. All right, let's try this. I think this is related to the show. All right, so I apologize if you're trying to get in. You can't hear me anyway, but we will make this available and send you the link. All right, during the hearing might be run either by a magistrate or a judge. And the judge is somebody that's elected. So every probate court has at least one judge. Some have more than one. For example, Cuyahoga County has 2 judges, so it might be either one. And then the judge may assign the hearing to a magistrate who is an attorney that's hired by the judge to do some of that they delegate some of the functions to. Typically, we are in front of a magistrate unless the guardianship is going to be contested or there's people fighting over who should be guardian. Then the judge might hear it. The burden to prove that a guardianship is necessary is on the applicant. And what they have to show is that the individual is incompetent, and usually the evidence for that is the statement of expert evaluation, as well as showing that there's a need for some decision making. There is no less restrictive alternative. In other words, we don't have powers of attorney, and that the guardian is suitable, the applicant is suitable. And this has to be, and the burden is that the applicant has to meet is clear and convincing evidence. So if you're wondering what is clear and convincing evidence, so this is the burden of proof. So think of this line as the burden of proof. And when we have think of like if there's a civil lawsuit where we're suing somebody for damages, for money, say there's a car accident and we wanna sue somebody. Our burden of proof to show fault is preponderance of the evidence. So that's the preponderance is about little over 50%. So the chances are that the person's at fault more than not. If we are being charged with a crime, then the burden of proof is higher, and that is beyond a reasonable doubt. So if you watch some trial about some criminal, somebody killed somebody, in order to convict them, you have to convince the jury or the judge that the chance that they committed the alleged crime is beyond a reasonable doubt, that you believe that they did that. When we're talking about guardianship or a will contest, then that burden is somewhere in the middle. It's clear and convincing. So it's more likely than not, but it's not quite as high as beyond a reasonable doubt. And the reason we have the clear and convincing standard is because we're talking about taking away someone's legal rights. When we establish a guardianship, we are taking away the individual's legal rights. So it has to be higher than a preponderance. Probable cause is the burden that the police has when they pull us over, and because of they have to have some probable cause of why they're pulling us over. And then suspicion, reasonable suspicion, is the burden to when we report child abuse or elder abuse. There's certain mandatory reporters that have to report, and the burden is very low. And that's because we want to encourage reports of suspected abuse or neglect. All right, special considerations in guardianship. So if a person is placed under guardianship, they still have their certain rights. They can vote if they're able to. They can drive if they are able to pass a driver's test. And if they want to get married, they have to get approval from not just the guardian, but also the court. And by the way, if they do marry, then the guardianship of person will terminate upon marriage. If they want to create a will, they have to seek court approval, where the court will make a determination whether that they have the requisite cognitive capacity to do a will. All right, post-appointment review. So once we get appointed guardian, then every 2 years, sometimes it's every year, again, depends on the court. We have 88 probate courts in our state, and we have 88 sets of rules. So one of the challenges for us is to make sure that we're familiar with a particular court's rules. So every 2 years, the guardian is expected to file a guardian report as well as a guardian plan. And that's really more like a report to the court on how often they see the ward, what kinds of goals is the ward working on, what kinds of services they're getting, that kind of thing. If the ward is contesting the guardianship, sometimes we have an individual who's under guardianship who says, I don't need a guardian anymore. They can request once a year a guardianship review to see whether they still continue to need a guardian. Motion to review, anytime somebody thinks that that the guardian is not acting on behalf of in the best interest of the individual, they can ask the court to review the guardianship, or they can file a complaint, and then ultimately that court will have a hearing, and if they agree that the guardian's not acting in the ward's best interest, they will order the guardian to do whatever they want to do, or they can remove them, because ultimately the court is the ultimate guardian, superior guardian. All right. as I said, the probate court is the superior guardian. So if, what that means is say the guardian can't act, maybe they're sick themselves, they're in the hospital and a decision needs to be made, then the court can be contacted and then the judge will give the decision. They don't like to do that. They want the guardian to do it, but ultimately it does fall on the court. And that what that also means is the guardian always has to follow the court orders, and otherwise they're going to get removed. Okay. The guardian duties are, once they're appointed, is they have to act in the best interest of the ward. So all their decisions must be made in considering what is the best interest of that ward. They have to follow all the legal requirements that the court sets, submit the reports on time, and then comply with any court orders. And then they may need to get mandated training. So I'm saying may, because again, it's very court specific. The training, if they are mandated, if the court is following the training, guardian training, then what that involves is doing 6-hour online training after they're appointed in Lorain County. They give you 6 months from the date of appointment to do the training. So you sit at your computer and you watch an educational video on what are the duties of a guardian, what can the guardian do. And then you get a certificate that the court gets a copy of that shows that you have completed the training. And then after that, every year you have to do a 3-hour training. Some courts don't do it because they don't have the manpower to check on guardian training, and they'll just give you a handbook that'll say, here's the duties of a guardian, please sign off that you read it and understand it. So you need to know what your county court requires. All right, if there's a change of residence, then the guardian for that ward, then the guardian has to notify the court if that there's been a change of residence. If that change of residence is going to be to a more restrictive environment, then they have to get permission from the court before they can move the individual. If that individual has a will or any other legal documents, then you have to notify the court of that and where they're located. And if there's any change in status, say they are institutionalized or they pass away, those are all that all requires notice to the court. All right, guardian duties. If there are complaints, then they have to help the ward. They have to, as we already said, follow court orders and provide response to the complainer. If there is any suspicion of abuse or neglect, they have to report that. And then and we already talked about representative payee for Social Security, and that if that individual becomes the rep payee, then they do not need to become guardian of the estate because Social Security is going to monitor how those funds are spent. And then what the court requires is that guardian meet with the ward at least every 3 months. That, you know, typically when it's a parent who's a guardian of a child, they're going to every day usually, or once a week if they're living somewhere else. But in other guardianship situations, especially if we have a lawyer acting as a ward for somebody, the requirements are that they see the person once or at least 4 times a year, and that any planning is person-centered. In other words, considering the individual ward's needs and wants. When do we terminate a guardianship? Well, if the ward is no longer incompetent, then there is no more need for guardianship. It will be terminated. That includes And that would require a new statement of expert evaluation where the doctor says, we don't need this person doesn't need a guardian, or, and then the guardianship terminates. If the guardian resigns, it doesn't terminate the guardianship because it's not saying the person's no longer incompetent, but the court will need to appoint a new guardian. And then when the guardian is removed because the court decides that they're not acting in the best interest of that ward, then that ward will be, then that guardian will be removed. And again, if that individual still needs a guardian, then they'll appoint somebody else. The bottom line, after having gone through and talked about guardianship, the bottom line is we want to avoid guardianship if possible. And that's because you can see you're adding a whole layer of oversight, which is the court, if you have to be a guardian, and it's going to be costlier. You're going to have more rules to follow. And then it also reduces privacy because all of this stuff is a public record. So how do we avoid guardianship? One way is if our individual is able to have sufficient cognitive capacity to sign a power of attorney, giving mom or dad or both or a sibling the authority, the legal authority to make medical decisions or handle their finances. So a healthcare power of attorney is for medical decision-making as well as where the person's going to reside. That the agent, the person that gets appointed as to act under a healthcare power of attorney on our behalf is called the agent. And then they can make decisions anytime the individual, the principal, is unable to make informed consent. In many cases with children who name their parents as agent, they can sit in with the doctor appointment and help make a decision, as well as in placement and all non-financial things. The durable general power attorney does the same thing with respect to funds, finances, and dealing with any money. And as I said, if we're just dealing with Social Security benefits, we don't necessarily have to worry because we have the ability if we're the rep payee. But if there's other funds, so say that child is working and earning an income, or they receive an inheritance, then we want to have, if we can, a durable power of attorney so that somebody can manage those funds for them. The other documents that we want to have are advanced directives for end-of-life care. An advanced directive is something like a living will. So, when you go to the doctor, they're always asking you, do you have a living will? So living will does not designate anyone with legal authority to act on our behalf. What a living will does is that it is our own instructions to the providers, to the doctors, about our end-of-life preferences. And in order for the living will to come into play, we first of all have to meet the definition of being considered to be at the end of our life. And that's defined as 2 doctors have examined me and they both agree that I'm either in a permanent irrevocable state or my death is imminent. If they both agree that that's where I'm at, then the living will says, give me comfort care. Don't give me aggressive treatment. Don't pound on my chest. Just give me comfort care. Keep me free from pain and suffering. Lastly, there's also a mental health directive that's similar to a healthcare power of attorney, but it's specific for individuals that have a mental health disability or mental illness disability. And what it allows is for that individual, when they're considered to have sufficient capacity to be able to designate someone to be their proxy for seeking psychiatric treatment, medication. It's specific to mental health treatment. And what makes it unique is that from a healthcare power of attorney is that a healthcare power of attorney and the durable general power of attorney, they are revocable documents. So the individual that appoints you as agent can change their mind at any time and say, yeah, I don't want you to be acting on my behalf. With the mental health directive, it is revocable, except that if that individual is in a moment, maybe their mental illness has flared up and they're not considered to be able to make decisions for themselves, then that mental health directive cannot be revoked until they kind of get through that period, and then they can revoke it later. All right. So here's some special issues that are specific with a mentally ill population is that if they refuse, say they're in a psychiatric hospital or an institution, and they tell the doctor, I don't want you talking to my agent, then the doctor won't, because they have to follow what the patient wants. The only option would be to, at that point, go seek guardianship, and then they would be able to talk to the doctor. This is true, by the way, also in other disability areas. So I'm thinking about maybe we have a child with a developmental disability, and they become vulnerable to other people manipulating them and saying, oh, don't make, don't let your mom be your power attorney, don't let her do that. And so they can, in those situations, the power of attorney may not be sufficient because they are always revocable. And so there may be other situations besides mental illness where it may not be sufficient, and that the only way we can really protect the individual is to seek guardianship. But whenever we are considering one or the other, we like to err on the side of, let's try the powers of attorney first, because they're less restrictive, they're easier to deal with, we don't have to go to court. And then if that doesn't work, we can always seek guardianship down the road if necessary. All right, so that's the end of my speech on guardianship. Estate planning, the formal tools, or sort of the basic estate planning documents that we look to have in place are the will. We always want to have a will, which tells us, which deals with who's going to get our probate assets when we die. Probate assets are those assets that are just in our name. So it could be our car. It could be our house. It could be a bank account. If we don't have an additional owner on that, named on that asset, or we haven't designated a beneficiary, that will be a probate asset, and somebody will have to look at the will to figure out what happens to that asset. Trust is another document, and I'm going to let Helen talk about trusts, because we're going to be talking more specifics about, especially about special needs trust. But trust is another vehicle that we can put our assets in, and then if we have them in a trust, in other words, the trust owns that thing. It could be a house, a car, it could be anything that you or I can own in our own name. But if it's in a trust, it's not going to be going through probate court. There'll be a non-probate asset. Durable powers of attorney. So again, we talked about those a little bit. And this, this slide really is talking about what all of us need to consider having. Maybe not the trust if our situation doesn't require it, but definitely a will, definitely a durable power of attorney. So we have somebody designated who's going to be our surrogate decision maker and have legal authority while we're alive if we're not able to manage our bills, our finances, anything financial, that we have a trusted person that we've given legal authority to act on our behalf. Healthcare directives includes the healthcare power attorney. Again, same thing, while we're alive, and not necessarily end of life. It could be something as basic as I'm in surgery and a question comes up about the procedure. And rather than having to wake me up and start all over again, the doctor can go out in the hallway and talk to my agent and get a decision about what should we do. So a healthcare power of attorney gives us that ability to do that. And then a living will, again, we already talked about that. That's end of life treatment wishes. And when we have these documents in place, what we're doing is we're avoiding the need for guardianship. And we are designating prior to needing the people we want serving in those roles. Because if we don't do this, and the need comes up and we've lost the ability to be able to handle these things ourselves, then the only option is to seek guardianship. Our spouse, sometimes people think, well, I'm married, so my spouse has that legal right, and they do not. So for example, with respect to our finances, yes, my spouse can access money in our joint checking account, but he can't access anything with respect to my 401k because that's just in my name. So he would have to have a power of attorney to be able to do that. All right, and then the additional documents to consider, the prior slide is sort of the basics, and then this is the additional. So we, in our own estate planning documents, we will do a HIPAA release along with the other documents. So HIPAA is our federal law that protects our patient privacy, and what it says is that doctors and medical providers, caregivers are not allowed to release any of our information or disclose any of our information unless we gave them permission. And so we do a HIPAA release prospectively, and it'll say something like, I hereby authorize anyone that treats me now or in the future to share my information with the following family members. And so we might name our spouse, our children, and that way we're avoiding, hopefully, in case of some medical emergency, and we have a child that lives in California and they're calling in and saying, tell me how my mom's doing, then they're not going to be told, sorry, we don't have permission to speak with you. So we have the HIPAA release there for that. A DNR is a do not resuscitate. It is a medical order. And that is something that can only be issued by a doctor. And it's speaking to if you don't want to be resuscitated, if your heart should stop, or the different situations, then the DNR will be in place. If you want to be an organ donor, there is a form for that. I know for many of us, we elected that on our driver's license. I don't know if they do the little red heart anymore, but it was some sort of a symbol that showed that we're in the organ donation program. There is a separate form, however, if you wanted to be specific about what you want to donate and what you don't want donated. The form lets you specify, whereas if we have it on our driver's license, it's for any purpose or any body part that they find usable. And then in Ohio, we also have a form that's called the appointment of representative for disposition of bodily remains. So if we wanted to give some specific person the authority to be in charge of our funeral, or whether we're cremated or buried, we can complete that form, and that will be honored. All right, so I'm going to stop here and turn this over to Helen, and then we will get to your questions. How do I see that they're seeing? They see blue on your list. other than that shaft.
Just so that anyone, like, I don't see them, I don't see
No.
myself.
Do you want to see them?
No, I want to make sure that I'm like,
Yes,
so I want to see me.
right. Oh, you want to see you?
Yeah. Participants.
Yeah, maybe click on that. Admit all. Can you hit admit all? Sorry, folks, we just figured out how to let the people in the waiting room in. No, this is all related to the
I see.
PowerPoint.
I think it's fine. I just,
All right.
hopefully I'm in there.
Bear with us.
Okay.
We're in that one. We didn't take it.
Okay, good morning, everybody. I met you very briefly at the start of this presentation. I'm Helen Rapp. I'm one of the associate attorneys at the firm, and I joined Hickman Lauder last summer, and my practice is primarily focused on special needs estate planning with some general estate planning. And I wanted to just share that, like many of you on the call, I have a child with a disability. I have a 27-year-old daughter who has cerebral palsy. And so it's very easy for me to put myself in your shoes. And the things that have you coming and attending a class like this are the things that I'm interested in too. And so I'm really proud to be working for this firm. And I hope in the future, maybe that I can help you put together plans that make sense for your families. Okay, so Helena just went over general estate planning documents, things that everybody should have, whether or not they have a person in their life with a disability or not. But when we get into the area of special needs estate planning, when we are parents who have a child who is disabled, there's some very special considerations that we need to make. And trusts can become very important in this arena. There are a lot of reasons why people or families might choose to have a trust. But if you have a person, a child with a disability, and you know that that person with a disability is going to either now or in the future depend on government benefits, namely SSI and Medicaid, then you're going to have to be really mindful of making sure that you're living, or that child is living within those very restrictive income and resource limits. And so how do you do that? Because they are pretty restrictive. The person can only have $2,000 in countable resources. And a trust can be a very effective way of doing that. And so that's what we want to spend the next part of this presentation talking about. And there are several different types of trusts. We're going to cover a few of them here. The first thing that you need to think about is, whose money is it? Is it money that belongs to the disabled beneficiary, or is it money that belongs to anybody else? So if it's money that belongs to the disabled beneficiary, then what we're looking at is a first party trust. And in our law firm, we call those trusts special needs trusts. And this can get a little bit confusing because sometimes people will call all trusts for people with disabilities special needs trusts, first or third party. But when we talk about special needs trusts, we're talking about first party trusts. And those are trusts that are funded with money that belongs to the disabled person. And we'll get into in the next couple of slides exactly what type of money that might be. Third party trusts are trusts that are funded with money that belongs to anybody but the disabled beneficiary. And so another common name for those trusts would be wholly discretionary trusts. And we're going to talk about those too. And then the third type of trust that probably fewer people know about, but that could be an important option, are pooled trusts. And those can be first party or third party, and I'll explain that in just a little bit. So those are the trusts that we're going to talk about. And then we're going to conclude today's session talking about stable or able accounts, which could be a good partner tool to having a trust.
Everybody's muted.
Okay,
Okay,
are we doing okay?
yeah,
All right. Okay, so now we're going to talk about first party trusts. These are the trusts that are just said in our firm, we call them special needs trusts. You'll also hear them referred to as Medicaid payback trusts. And strangely, another weird term for them would be a D4A trust. So why a D4A trust? And that's simply a reference to the federal statute that authorizes these trusts that's listed there, 42 USC 1396 PD4A. So we shorten that and call it a D4A trust. These trusts are funded with money that belongs to the disabled person. And you might say, my child is disabled, they don't have any money. But they might have received an inheritance, maybe a well-meaning grandparent or relative died and left your disabled child some money in their will, which is wonderful, but that money then belongs to the child. And so if you put it in trust, it'll have to go into a first party trust. Similarly, maybe your child is disabled because of a birth injury or a car accident, and maybe there was a lawsuit and they got a settlement. That money belongs to them. And so if it goes into trust, it has to go into a first party trust. Another way that the child might have income would be in the case of divorce and child support. For the most part, if you have a non-disabled child support is going to end, when that child is 18 or graduates from high school. But if you have a disabled child, the court might order that one of the parents continue to pay child support beyond 18. Those children are called CASEL children. But once they turn 18, that child support money is theirs. And so if you're going to put it in a trust, it's going to have to go into a first party trust. There's a couple of other reasons why you might have money that belongs to the disabled beneficiary. Sometimes, unfortunately, people might have a third party trust that just wasn't drafted correctly, and so it doesn't meet the requirements. That money might then actually be attributed to the child and need to go into a first party trust. Or if there's like a large back payment from Social Security, that would be another example of funds that would go into a first party trust. Okay, so who can create a first party trust? Well, the beneficiary themselves can create it if they're competent. So say your disabled child is, now 25 years old and they're disabled, but they're competent, they're not under guardianship, they can set up their own first party trust. You as the parent can set it up, grandparents can set it up, legal guardians can set it up, the court can order it. So an important thing to know that in order to have one of these first party Medicaid payback trusts, the beneficiary has to be disabled and they have to be under the age of 65. There will be an exception, and we'll talk about that when we talk about pooled trusts. But for the most part, just remember they have to be under 65 to set it up. And here's probably the most important thing about a first party trust, and the thing that most people would consider is not beneficial. They have to have the payback provision for when the beneficiary dies. And basically, this is the Medicaid payback. Many times disabled beneficiaries have, for many years or maybe their entire life, been receiving Medicaid. And so the state or multiple states that they've moved have paid for their health care And the state will have a claim against that upon their death. And so any money that remains in a first party trust when the beneficiary dies, before that money can go to anybody else, the state has a claim against it. And, you know, that could be sizable. Health costs are, you know, really high. And if your child has been on Medicaid for years or decades or their entire life, it's entirely possible that if there's money left in the trust when they die, the state will take all of it and there will be none left for other beneficiaries. Additionally, the trust must be for the sole benefit of the disabled beneficiary, and the trustee who cannot be the beneficiary must have essentially complete discretion to decide what distributions should be made. Okay, so now we're going to talk about third-party trusts. These are trusts that oftentimes you as parents or grandparents might set up to sort of make a nest egg for the disabled beneficiary so that, you know, they're going to have the quality of life that maybe they had while you're alive after you're dead. And parents can incorporate this as part of their estate planning process. So these trusts can be established by any third party, really, for the benefit of the disabled beneficiary. The disabled beneficiary cannot set it up for themselves. Anybody can contribute except for the disabled beneficiary. And we've listed here the chapters of the Ohio Revised Code that govern third-party trusts in Ohio. And a really important thing that we can't stress enough is that assets that go into this trust must be assets that were never owned by or belong to or possessed by the beneficiary. So if your disabled child is working, their income can't go into this trust. If they got an inheritance from a grandparent, it can't go into this trust. If they got a settlement from a lawsuit, it can't go into this trust. It has to be assets that they never were legally entitled to own. Now, the huge advantage of third-party trusts is that there is no Medicaid payback provision. The money in the trust never belonged to the disabled beneficiary, so the state doesn't have a claim against it. So if there's money in the trust when the beneficiary dies, that money, those remaining trust assets, can be given to whoever the person who set the trust up wants it to. So lots of times parents will say, okay, I have 3 children, one with a disability, I have a trust for that person with a disability. If that child dies and his siblings are still alive and there's money left in his trust, his siblings are going to share the money that's left in the trust, and you don't have to worry about the state taking it. So that's probably the single biggest advantage of a third-party trust. You can have a standalone third-party trust that's developed specifically as a trust for that person, or you can incorporate a third-party discretionary trust within your revocable family trust. It can be provisions that are within your revocable family trust. And you can include, of course, in your revocable family trust, your non-disabled children. It's just a part of your overall estate. So another thing that you can do that you can put into your trust is an advocacy provision. And what does that mean? Usually when parents set up a third-party trust for a disabled child, they are the grantor of the trust or the settler of the trust, meaning they're the person who created the trust. While they are alive, the parents will typically also serve as the trustee for the trust, because usually it's their money. They know their child better than anybody else. So it just kind of makes sense. But, you know, maybe the parents are getting older and they're no longer going to be able to serve as trustee. And so the trust is going to pass over to, you know, maybe a sibling, maybe some other relative, maybe a professional trustee like a bank or a law firm. But maybe it's somebody who just doesn't know the disabled beneficiary the way that the parents do. So you can build in an advocacy provision. And an advocate can be somebody who helps the trustee after the parents are gone. It can be a care coordinator. It can be, think of it as feet on the ground, not only for the trustee, but for the family. It can be somebody who is going to come and visit the beneficiary and, you know, make sure that their care is the way the parents would have wanted it to be. The care coordinator or the advocate can then report back to the trustee and to other family members. You know, they can help maybe find placement, places for the person to live, or caregivers to come into the house. They could, you know, help to buffer if there's disagreement among family members about what's in the best interest of the disabled beneficiary. They can be really, really useful, in particular after the parents are no longer able to act in that capacity. And so I've included a few more slides on care management, because sometimes people aren't aware that this is even an option. And so we did a presentation about a month ago called Trustee School, and we had a number of slides in that presentation, and I lifted them and inserted them here. That talks a little bit more about what can professional care coordinators do to help a family and to help trustees, you know, make sure that the disabled beneficiary is really being cared well for. Certainly the trustee could act as care manager. And if you, as the parent, are currently acting as a trustee, you probably are the care manager for your child. But what you want to do is just know that you can get a professional care manager for when you're no longer able to do that. If that professional care manager can fill the role that you, the parent, filled when you were acting as trustee. Usually professional care managers are people who have education and background in health and human services. Very often they are licensed social workers. They specialize in helping families that have either older relatives who might be looking at needing nursing care, or people with disabilities. And again, the care manager's role is to act as an advocate for the beneficiary and to guide the trustee. You know, they identify problems, they offer solutions, and as much as possible, they try to help the disabled beneficiary live, you know, the best life they can and the most independent life that they're able to. You know, they also, because they have expertise in the field that maybe the trustee does not have, they can assist with, you know, government benefits. They know the rules probably better than your disabled child's sibling does. They can make regular visits to the beneficiary. Let's say, you know, your disabled child has lived with you their entire life, and, you know, now you've set them up to live somewhere else, and their brother who lives in New York is serving as the trustee. Well, the brother in New York probably can't visit the beneficiary as often as you would like. The professional care manager can do that. They can also help the trustee decide whether or not disbursements from the trust are appropriate and are compliant with the restrictions of government benefits. If it's necessary, you know, for the beneficiary maybe to move to a group home or move to a different type of living arrangement, they can help make recommendations about that. They can, you know, professionally evaluate whether or not the care that the beneficiary is currently receiving is adequate or not, and they can make suggestions if it's not. And then they can usually once a year, you know, make a care plan for the trustee. So really they are just somebody who can help the trustee maybe fill the role that the parent used to fill. And so what we'd like to share with our clients is that in our firm, we actually do have a professional care manager. And so if you've been into our Cleveland office, you may have actually met Janelle Leonard. She's wonderful. She's a licensed social worker. And she serves as a care coordinator for a lot of our clients. And so she is available to work with trustees or successor trustees for the benefit of disabled beneficiaries. And trust resources can actually be used to pay for any professional care manager. So it's something to think about. Again, maybe not while you're serving as your child's own trustee, but something for you to think about for, what makes sense after I'm gone and there's a successor trustee acting. Okay, so this slide talks about important considerations, whether you're talking about a first party trust or a third party trust. These are things that should be in your mind really at all times. If the beneficiary is receiving SSI and you use assets from the trust, whether it's a first party trust or a third party trust, to pay for food and shelter, there is the strong possibility that their monthly SSI payment will be reduced. So Elena talked about the fact that in 2023, the maximum SSI payment that people can receive is $914 a month. That money, that SSI money, is intended to pay for food and shelter. So if the person who's receiving SSI gets assistance with food and shelter from any other source, including a trust, Social Security is going to call that in-kind support and maintenance. And they're going to reduce the amount of money that gets paid monthly to that SSI recipient. And it could be reduced by as much as about a third. I think it's $324. They could reduce that amount. So this is an important consideration. This is not saying you can't, that you can never use trust money to help pay the rent or to pay a utility bill. You just have to be mindful of the fact that if you do use money from one of these either first party or third party trusts to pay for food or shelter, that recipient is likely to have their SSI payment reduced. Sometimes it might absolutely be the right thing to do. You don't want them being evicted because they couldn't pay their rent. Better that they take a ding on their SSI than get evicted. But keep that in your mind. These trusts are, to be used for a number of things. It's best not to use them for food and shelter when possible. And then the other thing to remember is the disabled beneficiary cannot serve as the trustee for these trusts. They can't be able to compel distributions. The trustee has to be somebody else, and they have to have very broad, really complete discretion to decide how the trust money is going to be used. Okay. So the next type of trust that we want to talk about is pooled trust. And this is probably less well known. So you might be thinking, well, what the heck is a pooled trust? Pooled trusts are irrevocable trusts. And the key here is that they are managed by a nonprofit organization. And we have two of them in Ohio. We have the Community Fund Ohio and the Disability Foundation. You can also set up a pooled trust at one of the national pooled trust nonprofits. But if you're in Ohio and you're looking to set up a pooled trust in Ohio, well, you really only have two choices. And in many cases, you only have one. I think the Disability Foundation pooled trust is really for people who live in the Dayton metropolitan area. So most people, most of our clients, if they have a pooled trust, it would be Community Fund Ohio. And these trusts can be either third party or first party. So it can be for money that belong to the disabled beneficiary or for money that belong to you, the parents or the grandparents or anybody else. They can be particularly useful if you don't have anybody who can serve as trustee. And maybe you don't have enough money to justify having a bank or a corporate trustee served for your trust. Instead, the nonprofit group manages one overarching huge trust that people can have accounts in. So essentially, you would be setting up an account within this large trust, and it would be professionally managed by people who, have a lot of financial experience. It's still your account. It's part of a big trust, but it's your account. So it functions very much like any other trust would. It's just the trustees are, professionals, and you don't have to worry about, gosh, should one of my other children serve as trustee, or should I have a sibling serve as trustee? It's professionally managed fund. There's a lot of attractiveness about that, but there's also some red tape. So, you have money in this account, you have to go to the nonprofit to request distributions. Some people think that that's a little bit burdensome, but it can be a nice way of protecting the trust after you're gone. You might start out having a third-party trust that you're the trustee for, and you might build into that trust that upon your death, the trust will pour over into one of these pooled trusts that will then be managed by Community Fund Ohio. And then you don't have to worry. And you should think about who the successor trustee should be. You might have other children, and you might think, oh, my other children would absolutely want to step in and be the trustee for their disabled sibling. And they might want to, but they might not want to. They might be living several states away, and they might have their own busy life, and they just might not have the bandwidth, to step in and do the job that you were doing. And in some cases, it can set up friction if you have a sibling serving as the trustee for a disabled person. The disabled person might think, gosh, I shouldn't have to ask my brother or sister for everything that I want. They shouldn't have complete control. And that can cause some issues. It could damage the relationship between the siblings. And so it's not that it's never the right thing to do. And parents often want their other children to fill that role. You just have to think about it. You have to say, is this really the right thing for my disabled child? And is it the right thing for my non-disabled children to sort of put that burden on them? And if the answer is no, then a pooled trust might be a really good option. There are some fees associated with a pooled trust that you would have to pay to the nonprofit, but those fees are certainly less than the fees that might be charged by one of the big banks to serve as a corporate trustee. So it's just something that you should think about. It's an option that might be right for you now, or it might be right for you after you're no longer able to serve as trustee for your child. Okay, so I think that's enough said about the trusts for now. The last area that we want to cover in today's presentation would be able or stable accounts. And in Ohio, we tend to use those terms interchangeably, able and stable. And sometimes that's confusing to people, like, which is it? Is it able or is it stable? So able is the name of an account that allows people with disabilities to save and invest money without risking eligibility for government benefits. And it's a relatively new thing, and it's a great thing. It came into existence less than 10 years ago. So ABLE stands for Achieving a Better Life Experience. And so at the end of 2014, Congress passed this bill that said, for the first time, people who, maybe have SSI and Medicaid now have a mechanism for saving and investing money above $2,000 without risking eligibility for their benefits. And so every state has an ABLE account. In Ohio, the ABLE account is called stable. So that's why we tend to use both of those terms. You don't have to have an account in the state that you live in. We're actually very lucky that we live in Ohio. Ohio was, the stable account was actually the first in the country to open up. It opened up in, I think, June of 2016. So it's really relatively new. It's not, it's only been like 8 years. And Ohio was the first one to offer one. People from outside of Ohio can have a stable account. It's actually considered to be among the best in the country. So, in my opinion, if you're living in Ohio, there's really no reason to consider having an account other than a stable account. The disabled person can only have one of these accounts. So if the parents are divorced and both of them want to set one up, you can't do that. Okay, there can only be one ABLE/stable account per disabled beneficiary. This account is much like a college 529 account that probably many people are familiar with. And in fact, there's actually some ability to roll over from a 529 account to an ABLE account. Probably the only potential negative thing about a stable account or an ABLE account is that there is a Medicaid payback provision. So again, when the beneficiary dies, if that beneficiary had received Medicaid throughout their life, the state would be able to, file a claim against any money that's left in that account. Another thing to think about with these accounts, like if you have a grandparent who says, oh, I would like to, give $50,000 to my disabled grandchild. Well, they can't put $50,000 all at once into an ABLE account. There is an annual limit. This year it's $17,000. That's the maximum amount that can be put into an individual's ABLE or stable account. It's $17,000. That might seem like a strange amount. It's actually tied to what the federal gift tax exclusion limit is, which this year is $17,000. It typically goes up every year or two. So last year it was $16,000, the year before it was $15,000. Maybe next year it'll be $18,000, but it's not unlimited. So if you have a well-meaning relative who wants to leave some money to your disabled child, just keep in mind that you can only put a total from all sources of $17,000 a year into the stable account. The next bullet talks about if the disabled person is employed, there's the potential that you could contribute, an additional $13,590 a year. So that would give you like a total of over $30,000. Not everybody who works can do that. If you work at a job where your employer has an employer-sponsored retirement account, like a 401k type account, then you're not eligible to save this additional money. But if you don't have that opportunity, then you could put some additional funds in there. The really great thing about the account, though, is you can have up to $100,000 in it and not lose a dime of SSI. So, instead of having to worry that, oh my gosh, I have $2,005 in my bank account, you could have $20,000 or $25,000 or up to $100,000 in your ABLE or stable account, and there's no impact on your SSI at all. Now, obviously, at $17,000 a year, it's going to take you a while to get up that high, and we'll talk about whether it even makes sense to do that. There's a maximum lifetime contribution in an ABLE or stable account. In Ohio can only have $517,000 in it. But if you think about the fact that there's a Medicaid payback provision on these accounts, it probably doesn't make sense for you to use this as a place where you would park $500,000. Because when the person dies, that money is very likely going to go to the state. So we'll talk a little bit more about requirements of an able or a stable account. And then I want to spend a little bit of time talking about why these accounts can be good partners with trusts, that you can use the two together to accomplish what might be in the best interest of your disabled beneficiary. Okay, so in order to have an able or stable account, you have to be disabled, and the definition of disabled is the Social Security Administration definition, which, you know, if your child is receiving SSI or SSDI, you know, they automatically get this. You don't even have to prove it. They have to be disabled before the age of 26. So if you have a son or daughter who was in a car crash when they were 30 and now they're like a paraplegic, right now you could not open an able or a stable account for them. That is going to change. I think it's in 2026. It's going to up the age to, I think, 46. But for now, the person has to have been disabled before the age of 26. So, you know, is there oversight from Social Security and Medicaid? Sure, there is oversight. They could demand that you explain if there's a large or questionable distribution. They could ask for some documentation. They don't on a regular basis. It's good to keep good records. The money in the account has to be used for a qualified disability expense, a QDE. I would be hard pressed to tell you something that was not a QDE. So that's not a high bar for you to meet. You can use the funds.
The North Royalton Board of Education is at 6579 Royalton Road, North Royalton, Ohio, 44133.
If you could please mute yourselves.
Yeah, we're not sure what happened. But if anybody's not on mute, please check that. So anyway, funds from your able or stable account can be used for almost anything. And what's really nice, and I've underlined it on this slide, they can be used for food and shelter expenses. So if you remember, we talked about when your disabled child is receiving SSI, SSI is intended to pay food and shelter. If you use funds from a first or third party trust to pay food or shelter, their SSI payment could be reduced. There's kind of a workaround here. You can use funds from an able or stable account to pay food and shelter. And so sometimes we'll suggest that people have a trust and a stable account. And the trustee will be able to move money, you know, keeping in mind you can only put $17,000 a year in the stable account, but the trustee can move money from a third party trust into an able account, and then you can use that money to, you know, help with food and shelter. So I think when able accounts first came into play, there was thinking that, oh, this is going to eliminate the need for a trust for a disabled beneficiary. It really does not do that. So I think you shouldn't think about them that way. You should think about them as really working together as two different tools that can help you accomplish the best outcome for your person. Again, these accounts have a Medicaid payback provision. A third-party trust does not have a Medicaid payback provision. So if, you know, you're fortunate enough that you have sizable money that you can be putting aside for your disabled child, you probably don't want to have the bulk of it in an able account. You probably want to put it in a third-party trust and just have the two sort of work together. It's very easy to set up an able or a stable account. the account belongs to the disabled beneficiary. If that person is competent, they can set it up themselves. You, as their parent, can set it up. A grandparent can set it up. A sibling can set it up. A legal guardian can set it up. Sometimes a rep payee can set it up. It's all done online. You know, it takes probably under 15 minutes to do, so you don't need us or you don't need an attorney to set up an ABLE or a stable account. It's managed online. They have a debit card, a Visa debit card that you can request, that you can load money onto. So if your disabled child is, you know, able to handle some small amounts of money management, and maybe you'd like them to have a debit card, this could be a very controlled way for you to do that for them. They're relatively inexpensive, these accounts to maintain. They're not free. Currently, I think the fee for Ohio residents for a stable account is $27 a year, and they take the payments out on a quarterly basis. They take it out from your account. So they're not free, but you know, they're not terribly expensive either. So in general, it's a good thing. So I'm promoting it here, but I'm not promoting it as a replacement for a trust. It really isn't that, because again, because of the Medicaid payback provision and because of the fact that you can only put $17,000 a year in there. But the ability to use the funds in the ABLE account to pay for just about everything, including food and shelter, is really something that is nice. And so they're good partner documents. Okay, that is the end of what we had plans to cover. We do have some time that we wanted to take some questions. And I'm trying to think
it plays out and then just see the chat.
Yeah, let's see how we're gonna do that.
Stop.
Okay. So now we're going.
Just click on here for the. Oh, I guess it's over there. Let's see. Why don't we go up here? We can,
Okay.
all right, and then we can.
Check into the stable account, whether that means he doesn't lose benefits.
Okay, so. Do you want to sit here too? Sure. Steve on?
Very complicated.
Okay, so we've now maximized the chat bar so that we're just going to try to go through as many of the questions as we can in the time that we have left. So the first question that came in said, is this information going to be helpful for Canadians? So what we provided or spoke about today is very specific to Ohio and Ohio's requirements. Some things are more than so any of the discussion we had regarding SSI or Social Security benefits, that's federal. So I don't know how helpful that might be to someone in Canada. Maybe you have something similar, but hopefully just you probably would want to check with Canada's specific options, but hopefully this gave you some overview. I know they have, I think it's like a Hansen Trust or something. There's something in Canada that is very similar to our third-party voter discretionary trusts. And if that's something you have questions about, I know Janet and I had clients who were like dual citizens. Janet has contacts in Canada too. So you could reach out to us and we can help connect you. Okay, so how much money is allowed for, okay, this question pertains to the DD waivers, self-waiver, level 1 and IO waiver. How much money is allowed?
So if the question is how much money the person can have to be on a level 1 or another waiver, it's the same requirement that is imposed for SSI eligibility or just straight Medicaid, and that is $2,000 in resources.
Right. Unless you have it in a trust or a
Right,
stable account.
right, and exemplary, so, yes, just countable.
Right. So will a power of attorney fulfill the conditions for guardianship?
So that's, hopefully, I went through that, but it's usually you have one or the other. And as we spoke, if I have a preference of which I would prefer the power of attorney, because that is a private arrangement. I don't need court oversight. It doesn't cost much other than to establish it. And it's just easier as far as whether it fulfills condition. In other words, if you're asking, is it going to do the same thing that a guardianship is going to do? The answer is generally yes, unless that person who gave me the power of attorney refuses to let me do something, because the agent under a power of attorney always has to act, can't go against the wishes of the principal.
And then I don't think it's what was being asked, but I know recently I've had a couple of cases. Many times when you are the guardian for your child, you're really just the guardian of the person. And so it might make sense, and Elena covered this, but it's probably a good idea for your child to have a durable financial power of attorney so that you can pay their bills and talk to their
Yes.
creditors.
Yeah, for sure.
So we have a power of attorney. Are we still bonded?
You do not, the bonding requirement is limited to guardianship. It's not, you do not get bonded if you have a power of attorney.
Okay, so can you have two guardians, for example, the mother and the sister? That way, if something happens to the mother, the sister doesn't have to do anything to take over.
So when I have that, my preference, or what I try to do, is talk people out of being co-guardians, because it's just twice as many requirements. That might be more costly in terms of court fees. But I do have situations where we have a mother and a child as co-guardians, and that's when maybe there's some concern that the parent will not be able to continue much longer. So we want to have a child, so we have a seamless transition. But in general, I would discourage people from doing that, and instead say you have the mother be the guardian, and then the mother can do nomination of guardian form, so that the court knows, hey, if I can't be guardian, then I want my other child to be appointed guardian for their sibling.
So if you have a guardianship in a different state and you move with your ward to the new state, do you need to reapply for guardianship?
So Ohio participates in the Guardianship Transfer Act, and so you can, instead of having to do the whole thing from scratch, you would just transfer the guardianship to another state. And that, I'm glad that somebody's asking that question, because guardianship is state specific. So the rules in Ohio may not be the same as they are in Kentucky or Pennsylvania. And so there's been times where we've either had somebody move into Ohio from another state and we transfer the guardianship into Ohio, or vice versa.
Is a power of attorney a lifetime instrument or subject to renewal over a period?
Another good question. So once we execute a power of attorney, it stays in place until we revoke it. So it can be lifetime. Having said that, I know that with the durable powers of attorney for financial management, the financial institutions will get nervous if they see a power of attorney that's more than 10 years old. So they will either ask for a new updated power of attorney or some sort of certification that it's still valid. So if we're reviewing documents with someone and we see that their power of attorney is more than a decade, we might suggest let's do a new one.
Are there PDF worksheets available to fill out to help figure out, consider items with wills, trusts, and estate planning?
I'm not sure I totally understand. I know when we're doing estate planning documents for folks, we do a question, we will give them a questionnaire before our meeting. And then that will prompt them to fill in some parts about who they would want serving as guardian or agent, or for the will, who would be the executor, that kind of thing. But
Yeah,
I don't think we do anything beyond that.
no, I haven't seen that. So as a child gets closer to 18, how much time is needed to apply for guardianship? Should we start when the child turns 17?
Yes, we get that question a lot, and the court will not. Again, we got to think about which county we're sitting in when we're applying for guardianship, and there's some variations, but most courts will not have a hearing until after that child turns 18, or will not even accept an application for guardianship. Some courts will schedule it for really close to the birthday. But what I will tell you is that what ends up happening in reality, because parents worry that, oh, if I have to wait till my child's 18 and then we file, and then you're telling me it's going to be 4 to 6 weeks before we have a hearing, what if something happens during that 4 to 6 week period? And what happens in reality is, say there's some emergency medical need, doctors will act. They will, because if it's an emergency, they're going to provide care and on an emergency basis. And we will say, hey, there's a guardianship application pending. So I've never had a situation where something couldn't be done.
Can a guardianship be helpful in protecting the adult child from being taken advantage of? For example, somebody opening a credit card in their name.
I would say yes. It's more helpful and it's more protective than a power of attorney, because as I said before, that power of attorney can be revoked, or maybe they'll give a new power of attorney, they'll be talked into giving somebody else a power of attorney, because, oh, by the way, you can have more than one. Whereas guardianship, the guardian can prevent that, maybe not prevent it, but deal with it after the fact. So we've had situations where the child themselves goes and opens up a bunch of credit cards. The guardian can notify the credit card company, and then they incur debt. The guardian can notify the credit card company and say, this is not valid because they don't have authority to open up credit cards. They're under guardianship, and then we can make that go away.
What recourse does a guardian have if a ward makes their own will or will not cooperate with the guardian to do estate planning?
Well, I don't think a ward can be forced to do estate planning.
And they can only have a will if the court agrees,
Right. So if they make their own will, I suppose you can go through the process of having it set aside as not being valid. You do that through the court.
Is it necessary for a DNR to be part of the living will?
It is not. The living will can be personalized. So sometimes people will want to have, maybe say, I don't want to have any reference to a DNR, or maybe they want to say, I never want to have a DNR, and maybe they want to say, I want to make sure I have a DNR. So the answer is yes, you can make it specific to your wishes.
If trust money is used for maintenance on the home, like a new furnace, would that affect SSI payments?
If trust money is used, so if I read this question correctly, it's the home is owned by the trust, and the beneficiaries living in the house, in that home, and then the money to do maintenance, I don't think that affects SSI. I think if
I don't think
the trust pays for utilities,
it would.
it would,
Yeah.
but not furnaces. Furnace isn't considered a
No,
utility.
it's home improvement.
Yeah.
Yeah, so I think that would be okay. I mean, because the trust could remodel a bathroom too,
Yeah.
to put in a roll-in shower. So I think you'd be okay with that. Do assets in a third-party trust become an asset for the beneficiary if applying for SSI? Not if drafted correctly.
That's correct. I agree. We both agree. No, they do not. Because remember, third-party trusts and first-party trusts and the funds in those trusts are exempt. So SSI is only looking at countable, not exempt.
Right, you just, the trust has to be drafted correctly so that the beneficiary isn't the trustee and has no right to compel the trustee to do what they want them to do. So it just has to be drafted correctly. What can stable account money be used for and how do you use it? So it can be used for any qualified disability expense, any QDE, and that is just about everything. You know, and again, we covered this, but the beauty of it is you can use it to pay for food and shelter. You manage the account online, so you can, you know, you can request online a distribution, but you can have a debit card. There's a Visa card that you can request from your stable account, and you then can load money from your account onto that. So it's really pretty easy to use the funds from the stable account. Doesn't that just put a cap on what can be spent for the disabled child for food and shelter? I guess I'm not sure when.
With the reference.
Yeah. That question came in at 11:23.
Oh.
Maybe it was in relate to the stable account having the limit of $17,000 a year, maybe.
I think that the idea behind that limit is more tied into, well, it wouldn't be a 529 plan because they don't limit the annual.
No, it's what, I don't know why it's tied to the gift tax.
May I elaborate?
Sure, go ahead.
So the question was, what you had said that there was a certain amount of money per month that SSI maximum would send. I think it was $942. And then you said that money spent out of a trust might eat into that and the SSI might be lowered. And I guess my question was, doesn't that then just simply put a cap at $942 on what you can spend for a disabled child's food and shelter?
I think it's, I guess the way we look at it is that, and I think Helen spoke to this before, is that the SSI benefit amount, that it's $914, is supposed to be for food and shelter expenses. And so SSI's position is that if any third party contributes to food or shelter costs, whether it's a person or a trust, then therefore, that's what's going to cause the reduction to the SSI amount, because they don't want, because now they're getting subsidized. But it's not a dollar for dollar reduction, when we didn't go into this deeply, but what happens is they say, oh, this beneficiary is getting in-kind support maintenance, and under the SSI rules, they'll get up to a 1/3 reduction of their SSI benefit, but that's the limit. So if the trust is paying $1,000 a month for rent somewhere, they're not going to reduce the SSI to 0. They'll reduce it by whatever,
$324. It goes down to like $590 or something.
Yeah. Okay. So that's the pop. That's how they deal with that.
Thank you.
You're welcome.
Let's see. Can a guardian exclude a ward's gold digger girlfriend or other unscrupulous people from participating in estate planning meetings between the guardian and the ward?
Well, yes. I mean, and this is regardless of whether there's a guardian or ward. If there's someone doing estate planning with their attorney, then in this case, it would be guardian, ward, and attorney. Then it's usually good practice to exclude everybody else out of that meeting, because it's the ward's funds and it's the ward's wishes that are supposed to be followed.
Okay, so please explain the disabled beneficiary cannot be the trustee. They cannot be the trustee. So in order for the trust to not be accountable resource for SSI and Medicaid, that's a requirement. They can't be the trustee.
And if I can expound or add to what Helen's saying, one of the reasons is because one of the reasons these trusts are excluded and not accountable to that beneficiary is because the beneficiary cannot have any control over the funds in the trust. And so if they were the trustee, then they would be perceived to have control and decision-making power about what they use the funds for. So.
You know, in reality, if it's a trust you've set up for your child, you and your child are probably going to figure it out. So it's not like, I mean, but they can't be the ultimate decision.
Right.
If funds in a stable account are in the name of the disabled individual, say it's spent on college, will Medicaid recapture provision then apply to a third-party trust if it exists?
I'm not sure, and I don't know if this is asking, if this person's asking, if you use up the money in the stable account, can the state reach the third-party trust funds?
No.
And the answer is no, they can't. They're two separate things. So say, and I hope I'm getting this question. Say the person uses up their funds in the stable account and then they pass away and there is a Medicaid payback. So there's money owed to Medicaid. They can only go to that stable account if that was the only thing the person owned. And if there's not enough money, there's not enough money. They're not going to be able to go to a third party trust and require payment from that.
Right. I mean, it sounds terrible, but if you know that your beneficiary is in the last year of their life, spend down that stable account.
That's right.
And
we would say the same thing if they have, sometimes we have a beneficiary that has a third party trust and a first party trust. And you've got two pots, and we will tell the trustee, if you're managing both types of trust, always use the funds in the first party trust first, because that's the one that has the Medicaid payback.
if a working beneficiary deposits his paycheck into his stable account, does that mean he does not have to report earnings to SSI?
I would say you always report earnings to SSI, and they get that information through the IRS anyway.
Right, and you would just be saying, hey, it's going into your stable, it'll go into your stable account, but you still have to report it. So it's not that you're hiding the fact that you have a stable account from them.
Could I just explain a little bit? That was my question.
Sure.
So our son does work part-time and he has a stable account. And it's sort of a disincentive when you earn over $65 a month, then they start reducing SSI by $1 for every $2 that you earn. So my question is, if that money is deposited into the stable account, will they not reduce it?
They will. It's because think of it this way, the income for Social Security is different than a resource or asset. The money that's sitting in the stable account is a resource or an asset. And for that, they're not counting that. But that's different than the income. He's getting the paycheck and he's just depositing in a stable account. The income piece is the month he receives it, that's income. And that's where they apply that formula. Beyond, they disregard the $65, and then after that, take away $1 of SSI for every $2 of income.
Right.
They will continue to do that.
They'll continue to do that. Okay. Thank you.
You're welcome.
In the pool trust by Community Fund Ohio, don't any remaining funds of the beneficiary revert to Community Fund Ohio upon the beneficiary's death, therefore preventing remaining monies to be passed on to anyone else? So when you have a pool trust, remember, if it's a first party trust, there'd be Medicaid payback, but sometimes with the pool trust, and I think Community Fund Ohio, instead of it going back to the state, you can say, hey, I want that money to stay with the nonprofit. That's actually a nice option.
Yeah, and that's specific to state requirements. And and as Helen said, in Community Fund of Ohio, they do give that option to the individual. So some people choose when they sign up to say, if there's money remaining on my death, then I want to keep it with the nonprofit. And then they use that for their charitable purposes. But if they don't choose that, then it reverts to the state has to be repaid first for Medicaid, and then what remains can go to whoever they designate as ultimate beneficiaries.
Does Cuyahoga County require the annual 3-hour training for guardians?
They do not. They're the ones who require you to sign a book saying that you know your requirements.
If your will and special needs third-party trusts were created in a different state and you and the disabled beneficiary have since moved to Ohio, do those documents need to be redone?
So what we would tell clients that have recently moved is that you want to have them reviewed by an attorney in the state that you're sitting in. So if you're coming to Ohio and you did your documents somewhere else, you might want to have them reviewed by an Ohio licensed attorney who can look at it and say, you know what, this will be fine for Ohio laws. And the same thing, if we do your documents in Ohio and you're going to move, we're going to tell you, have them reviewed, especially if it's a special needs trust, because there is variation between states. In Ohio, we tend to not put in a lot of specifics as far as what the trust can be used for, because in Ohio, the Job and Family Services is looking at more of a discretionary standard than, oh, we can use the money for clothing or we can use it for trips. Whereas in other states, they're going to have a different requirements on that.
What makes a third-party trust drafted incorrectly and subject to Medicaid payback? Well, it could let the beneficiary be the trustee, or it could not explicitly state that the trustee has complete discretion on how to spend the money. Or it could have some type of ascertainable standard about how the money is spent. So there's very specific rules in the Ohio statute about how it has to be worded. And if it's not worded correctly, it could be deemed invalid. And then that money would then, have to be first party, have to go into first party.
Yeah, and I would add to that what we've seen where that happens is not so much the language, but that somebody has deposited that beneficiary's money into a third-party trust. Because remember, Helen said, you got to make sure that anything in a third-party trust never legally belonged to that beneficiary. So if somebody has deposited, say the beneficiary is earning too much money, and the bank account is growing beyond the limit, and so the trustee takes the money and puts it into the trust. Now you've commingled third party and first party money, and that might trigger Medicaid payback.
And then the last question, I'm sorry, we are over, but this is the last question. Ticket to Work. There are programs through Social Security that will allow additional exclusions for earnings.
That's true. And that, so say, the person needs transportation or some accommodations, then that'll be deducted from the income that they earn, or on paper, so that you're minimizing the SSI reduction. All right.
Okay, and
So
that's it.
all right. Well, unless there are any questions, we will wrap this up. And again, I apologize for the technical issues, and especially to those people that are watching this who didn't get to do the live webinar. This is my fault. But next time around, I will figure this out and hopefully the recording is, has captured all of the required, or all of the important substance parts of this presentation. So thank you very much for joining us, and I hope you found this helpful. Yes, so the question is there a way to access First Hour recording that was missed? You will, once it gets uploaded, we're gonna have it, and we're gonna email you the links as well as the slides. So thank you so much, and thanks for your patience.
Thank you, everybody. Thanks for your time today.
I had a
Bye-bye.
question.
Oh, go ahead, there's a question.
I just was wondering, what's the maximum that somebody on Social Security disability can earn per month? Working,
$1,470 a month. It's substantial gainful activity. So if you're on SSDI, you can work, but if you earn more than $1,470 a month, they're going to consider that you're not disabled. And so that would put your SSDI at risk.
okay, 1470, you said?
Yes, and that typically
Okay.
goes up a little bit every year too.
Yes,
Okay, I was just wanted a ballpark on that. Thank you so much.
You're
And,
welcome.
and sometimes it doesn't go away right away, like they might, I think there's a
you get
trial.
you get
there's-
9 months. It won't trigger a review until you've earned that much, at least that much for 9 months. They don't have to be consecutive months. They're in a rolling, I believe, 60-month period. But
Okay.
once you hit 9 months, then they'll put you in like a trial period for another 3 months. And then if you're still over that, then they will look and see whether you still meet the definition of being disabled.
Okay, thank you so much.
All right, you're welcome. Take care, everybody.
All right, bye-bye.
Bye.
Yeah. Maybe the other one.
Oh, and
All right, and meeting for all. No, down. There.